should just go ahead and get started. I know there are people, obviously, who are not on the video part, who are hanging out and watching the chat and watching the video feed, so we probably ought to go ahead and start. And I know that I think we ought to just go in order of the papers and talk a little bit about what our goals were with these papers, and then have a roundtable kind of discussion. And Kate, I'd love to have you chime in at any point. But we were going to, I think the plan was to have 4 or 5 minutes for each presenter to just talk about what the paper is about and what they're doing with this research and where they're going with it, and then have some comments. Is that right?
Yeah, I think we wanted to spend each presenter about 5 to 10 minutes, talking about their paper, and then 10 to 15 minutes of feedback from the group.
Yeah. Okay, Katrina, do you want to lead off?
Sure, and thanks for the opportunity to do so. I'm really glad to have some feedback on this at such an early stage, so I appreciate all of you for joining in. Just to give you a little background on the paper itself, it is a revised conference paper that I gave last summer at the Berkshire Conference of Women's History. And I did get a few comments regarding the possibilities of expanding my look at habeas corpus into more of a comparative international legal history, but there wasn't a lot of discussion about the actual habeas corpus cases themselves that I'm looking at. So I'm hoping to hear something about that from each of you today. This is meant to be expanded into an article that will sort of be my first entree into this book-length topic. So I intend to expand in 3 specific ways. One is that with what you already have, I'll be expanding the analysis of Standing Bearer's petition itself. So that'll come early in the essay itself in those first few pages. The next step I plan to take after sort of where the conclusion is right now is to turn away from indigenous petitioners to female habeas corpus petitioners and talk about those petitioners and their cases as a different category of habeas corpus claims. And then finally, to add some larger context to both these indigenous and female petitioners' claims, I want to talk about these incidents as part of a larger Reconstruction moment in the American West. I think that the way that habeas corpus is used in that historical moment is distinctive, and so I'm not quite sure what I would have to say about that because I haven't gotten deep enough into the rest of the records, but those are my plans, basically just to expand the Standing Bearer section, add female petitioners to the next section of the essay, and then close by giving it some context in Reconstruction era legal history. I did have some specific questions for those of you who read the paper. I was hoping to hear about suggestions regarding secondary sources that might be useful for me. I am still building that secondary literature, so I'd love to hear if you have ideas about other titles that aren't already in the footnotes. I'm also, perhaps as is clear, coming to this issue from a Western history perspective. That's my regional background. And so if other scholars here have something to add about the way this would have parallels in Southern history or in Reconstruction era history more generally, I'd be happy to hear about those parallels that you might see. And then, of course, just general comments about its merits and about its utility. So, thanks.
So maybe we should talk about Katrina's paper right away rather than go through all of ours. Do you want to do it that way? Is that
Sure.
Yeah. Okay. Who wants to go first? Hi, Tamika.
Hi.
How are you?
Good.
Good.
I'm glad I made it.
I'm too. So Katrina was just giving a a brief summary of her research and what she was doing with her paper. And I guess we should just um, respond and come up with some comments. Kate, do you want to lead off or?
Hi, thanks. Hi, all. I actually was under the impression that there was a formal commentator who wasn't me.
Okay. Leah hasn't been able to join us yet, so there is a commentator.
Okay.
I'm hoping she'll come on here soon, but I think we're in a mode right now of just offering feedback. I mean, I have some thoughts about Katrina's work too, but I didn't know. I want to defer to others and then come in. Or
yeah.
either.
Well, why don't you go ahead? I actually have been reading some stuff about 18th century English law and habeas corpus, but so I don't. That's where my head is right now. But so why don't you guys go ahead and then I'll jump in as seems appropriate.
Okay. I guess I'll start a few comments and then others can pick up. How about that?
Sure.
So Katrina, first of all, I love what you're doing with this project. I think it's absolutely fascinating, the idea of the various ways in which habeas corpus was put to use by laborers, Chinese workers, indigenous women, a whole range of different uses of habeas corpus in the West. And so I think the project's really, really exciting. And I suppose that I really was coming at this and reading your piece as a Southern historian and thinking about, and you indicate this with the Heo case, that it really, much of the structure of that experience is similar to free black experience or to enslaved experience in the earlier parts of the 19th century in the South, and the whole sort of property and labor regime that seems to be in place in that case struck me as very similar, especially the whole notion of who is subject to control and custody and under what conditions. And I just think there's a real opportunity for you, and I don't have much specific guidance right now, but to connect what you're doing to the literature on slavery and where it is right now. And in particular, I'm thinking of Walter Johnson's new work, River of Dark Dreams, and I'm also thinking about Ed Baptist's new work on The Half Has Never Been Told. But this sort of legal regime that surrounds slavery strikes me as very similar to some of the concerns you've raised in this piece, and so, I mean, there's a lot of secondary literature about this. I'm sure Tamika and Kate have suggestions as well, but I found it really exciting what you're doing there. And the other comment I would make is, well, I have another comment and a secondary suggestion. I think on the children and sort of this federal paternalism and the legal culture of collusion. I wanted to ask you about, more evidence for that. What's the evidence you think for the sort of legal culture of collusion that you describe?
I think I had to leave some of it out of this shorter draft, but I was able to, and similarly to some of the papers that I read for this workshop, show that the jurists and the people being petitioned against with the habeas corpus cases had social connections, that they shared a very strong social network. And so I'm suggesting with that culture of legal collusion that you had judges who refused to redeem the petitioners because they were in the same fraternal brotherhoods as the men who claimed these petitioners' bodies. So I think that was the angle that I was taking there.
The, um, on some of the work about children and children's labor, I haven't read all of her work, but Holly Brewer is doing a lot of excellent work in that area, and especially and Kate probably knows more about this, but Holly Brewer's study of sort of children's status and custody in the early period, meaning 17th and 18th century, I think could be really useful for you in thinking about, especially the first case you were dealing with in this piece. You know, I did wonder a little bit about the how you see the role of the white attorney in this case.
I definitely have over the past few conference presentations gotten more questions about that, and so clearly I need to look more into the backgrounds of those attorneys. I simply haven't yet, and so it's a question of whether those attorneys are sharing the same knowledge networks and reading the same legal pamphlets and guides and things like that. I think it would add a really rich dimension, especially because I hope to expand this into a multi-region study, so understanding how lawyers in the Southwest and the Pacific Northwest and elsewhere in the Pacific Rim even understood habeas corpus innovation would be pretty great. But thus far, I really can't speak to it because I haven't done the work to put those pieces together.
I'll invite my colleagues to make some comments and suggestions.
I'll just go ahead. Oh,
go ahead. I'm sorry, Tamika. Go ahead.
Oh, it's okay. It's okay. Go ahead. Oh, you can go ahead. All right. I'm going. Okay. Katrina, thank you so much for your work. It was really interesting to me. I'm not a Western historian. I don't have much expertise in this, but I'm really interested in how you sort of thought less about civil rights and thought more about its racial and gendered contexts. And I like your broader argument that these native habeas corpus petitions reflect gendered challenges to settler colonial patriarchies. I think John Hayo's case is very interesting because in that case, it actually while with Standing Bear's case, it seems that the judge was more interested and sort of agreed more with the Declaration of Manhood that was happening there. But in John Hayo's case, it's very interesting because it seems like federal officials were more interested in facilitating patriarchy while simultaneously denying sort of these ideas about autonomy that are assumed in patriarchy. And so I'm wondering too if in your use of the term maleness has to be sort of tricky. Because you can't really use patriarchy to think about men in Native communities as much because that patriarchy is always subject to the interventions of the law. And so I was interested on page 10, you talk about how federal jurists they failed in protecting indigenous humanity. And I was wondering if you got a sense from your sources the perspective of indigenous peoples in terms of how they viewed the courts, how they viewed the legal system more broadly. Did they see the system as protecting their interests, or were they sort of maneuvering and manipulating it in a way that served their interests as sort of an assertion of autonomy? I mean, because that's sort of how I looked at enslaved women. There's not necessarily this expectation, right, that this legal system is going to protect their humanity or protect their interests at all. But there's this idea that there's this entitlement to be able to engage in the legal system and sort of I was just sort of interested in that because there's this language of they failed to protect indigenous humanity, but is because that was not the purpose of the legal system at that time, at least in my mind, I don't think it was.
Right.
How do you make sense of Native approaches to the legal system and sort of their perspective about what this governing system that regulates their day-to-day life?
I think that in terms of indigenous perspectives on the American legal system, mostly scholars have looked at that from the position of treaty diplomacy and treaty negotiation and tribal claims in the federal Supreme Court, or more local jurisdictions, but still as tribal legal actions, not necessarily looking at the individual indigenous petitioner or claimant. So from that treaty history perspective, there's a pretty strong body of evidence showing that Native people actively engaged the legal system, that they had really sophisticated understandings of the American legal system, and that they did expect to be able to be, quote, I wouldn't really say protected, because that does kind of suggest a paternalist view, but they used the language that was presented to them in seeing, the federal father, the great white father kind of mentality. And of course, I think that they used that in a real savvy way, not in just a sort of a one-dimensional way, but basically from the colonial contact period forward, you have a real strong practice of engaging and holding the legal system to account in the interests of Native people. Now, as individual petitioners, it's difficult for me to say very much about those people's perspectives because I have less evidence outside of the actual petitions that they filed or the cases that they generated. And in a lot of instances, those indigenous petitioners or claimants weren't allowed to actually testify. So I'm kind of borrowing from the treaty literature to talk about indigenous viewpoint, but I don't necessarily have the evidence of indigenous viewpoint in the cases I'm looking at. And I think that speaks back to Will's question and others who have asked the same question about the role of lawyers. Because we don't have evidence of indigenous people saying, I want to use habeas corpus this way because I think this about the American legal system, then we're sort of deferring to lawyers' interventions there. So I think I'll probably be doing a lot of work to explore and build that sense of how these particular petitioners viewed the legal system. As far as the difference between Standing Bear and HEO and their views of the legal system and the role of patriarchy and their access to autonomy in those particular cases, I think that the federal judge in Standing Bear's case recognized Standing Bear's masculinity as one that coincided with his own patriarchal values, whereas HEO had been charged with abandoning a wife. He had been, sort of, you get the sense that he is overly mobile. That is, that he's leaving the reservation and coming back, and he's traveling amongst the area farms to find work. And I think that he may have overstepped the bounds of an appropriate form of Native masculinity in the eyes of the legal community there in Washington. And so that's something I would develop as a distinction between Standing Bear's ability to claim masculinity in the law and HEO's inability to claim that same masculinity. Does that kind of address what you're asking, Tamika?
Yes.
Dr. Jagodinski, what I found interesting was your emphasis on the language in these appeals. For instance, I'm a man or I'm a mother rather than a woman. So I was wondering, there probably isn't much evidence of these sort of speeches given, but I was wondering how much of these habeas corpus cases is there an appeal to humanity rather than legal work being done in terms of legal justifications?
I'm not 100% sure that I see those as separate in these particular cases. Um, I I think what intrigues me about habeas corpus petitions is that they are at least in my view, a legal mechanism to establish humanity, and I think I see them more as human rights than civil rights, even though that's a distinction that's not quite being made in this period in the law. Um, so I guess maybe you can help me out by rephrasing the question.
Well, I was thinking, in the cases you've seen or the documents you've looked at, how common is it to appeal to the judge's humanity rather than some sort of legal argument?
Oh, well,
you would think that is legal, but
sure. That process is distinctive to the indigenous petitions that I've looked at. I don't see, for instance, the male working class white laborers in their petitions. They are not arguing about their humanity. They're arguing about the legality or illegality of their in confinement. And the same is true with white female petitioners. They're not. They are claiming a maternal status in regard to their children, but they are not making claims to a humanity. So I think it's on indigenous petitioners to make that claim, whereas other petitioners don't have to do that work, so to speak, in their petitions. I have not, although I'm collecting, I have not read the bulk of the Chinese petitions. So it would be interesting to see if they are having to make that claim to humanity, just as indigenous petitioners are. But I think I could make a note of that, if that would be helpful for readers.
the other thing, Stacy Smith's Freedom Frontier, I don't think I saw that in your notes, but just for dealing with these sort of legal process in the West during the same period and the mixing of cultures, ethnicities.
Stacey Smith's Legal Frontier?
Freedom's Frontier.
Yeah.
It sounds familiar, and yet I'm not sure.
Can I jump in with a couple of comments?
Huh?
So yeah, I think this is really interesting too, and I have been, as I said before, I've been sort of going back to English law, like where did all this stuff come from anyway, which is basically from English common law. And I mean, I think one thing that's interesting for this case, and for a lot of the times when we're dealing with habeas corpus proceedings, is that it actually has nothing to do with citizenship, as far as I know. And so it's basically like a procedure that any human being, and the big question in England and with Somerset was, is a slave, an enslaved person, entitled to have a writ of habeas corpus on his or her behalf? But habeas corpus, as I understand it, by the 18th century, was considered to be something that every person, certainly every free or nominally free person was entitled to, man or woman. It wasn't gendered. It wasn't about citizenship. It wasn't about, like, you could be let's say in England, you could be a foreigner. You didn't have to be an English person to be entitled to kind of have your case heard before a judge in a habeas corpus proceeding. And so I think when we think about the U.S. context, it's sort of course, it stands to reason that people who are marginalized by the system, who are not considered citizens, who are considered racially other or any kind of other, would go to habeas corpus as a way of asserting claims. And so I think I think it's a great place to look, and I think the notion of looking at, lots of different people's relationship to habeas corpus, not just Native Americans, but lots of different people, I think it's a great idea, especially as a historian of the American West. But I would watch out a little bit for the conflation of the terminology of personhood, human rights, as you said, versus citizenship, because I think they're very different, and I actually think that the difference is really important for history, for understanding history. And so in that respect, I would also just suggest, Greg Downs and I co-edited a volume of essays that's coming out this fall, and Steve Kantrowitz has an essay in there about the Ho-Chunk, that talks about that kind of weirdly citizen non-citizen category that emerges in after the 14th Amendment. And Laura Edwards has an essay in there too that is about the transition of jurisdictions. Like, one of the things Reconstruction makes possible, obviously, the Habeas Corpus Act of 1867, the 14th Amendment, all these things make it possible to transfer, the Civil Rights Act of 1866, to transfer your case from a local court to a federal court, or to go straight to a federal court. And what your people are doing are going to federal court. And that is a very Reconstruction moment. That's would never have been possible right before. There would never have been a recourse to the federal courts. And Laura Edwards' new book that just came out with Cambridge University Press, which is a legal history of the Civil War and Reconstruction, is also really good on kind of pinpointing that change of jurisdictions, the way that the Reconstruction made that possible. So in that sense, I do think it's very much a Reconstruction story. And I think like what you're describing is also an example of stuff that we're familiar with from Laura's work and other people, which is the ways that marginalized people use the courts opportunistically. And so it's not necessarily that they're committed to any one kind of procedure or any one kind of assertion of rights, whether they'll adopt the language opportunistically too, whether it's a language of masculinity or a language of dependency, or it's basically they're just using these forums as an opportunity to kind of get what they want done. And if the federal courts open up as a possibility for getting it done, then go to the federal courts. So I think that that kind of very pragmatic, opportunistic use of institutions is something that what you're describing shares in common with things that Laura's shown, even going back to her first book, Gendered Strife and Confusion. And then on the children thing, just one more little citation. Catherine Jones has a new book on children in Reconstruction in the South, and it focuses on Virginia. So I don't know. I mean, she takes a different approach. It's a more social history approach. She's not necessarily specifically interested in the law, but she does have a lot on indentures and orphans.
Okay. All of that.
Yeah, feel free. I mean, I don't know. I just threw a lot of stuff out there, but yeah. I don't know if you. Yeah.
I kept notes on everything you were saying, so I may follow up later with an email if that's all right, in case I missed some of the names. But I absolutely think you're right that right now there is a lot of really interesting literature on some of the legal opportunities that are unique to that Reconstruction moment outside of the South, and so I'll definitely take a look at that Ho-Chunk essay because I'm interested to see that, and then any opportunity to read more of Laura Edwards is something else. So thank you. And can I just follow up by asking, do you know when the anthology is coming out that you did with Trade Guns?
In September.
Okay, so I'll look for that.
Yeah. And if you want, I think I could probably send you the. We're about to get the page proof, so I could send you the essays, or just with permission of the authors.
Yeah.
Okay, that'd be great.
I'd love to see that.
But Laura's book is out. I think the Civil War and Reconstruction book is out with Cambridge.
Okay, great.
But so, let me follow up because I'm here to learn a lot too. Like, do you agree about the sort of specifics of what purposes a habeas corpus proceeding can serve, and the ways that it comes to the very basics of personhood, as opposed to having to have any kind of citizenship or national belonging or race or whatever component?
Absolutely, and I think that that you're right, that it then becomes a mechanism that attracts marginalized people because it's something that's open to them and open to so many innovative applications, and that's what I'm hoping to show. I think that my sense is that the Southern legal history scholarship on habeas corpus and marginalized legal actors is more advanced than the Western legal history literature on either habeas corpus or on marginalized legal actors. So probably for anyone who's a Southern historian, or anyone who has a sense of the the transfer of English common law to American common law in the colonial to early Republic period, these are issues that have been very well examined in the secondary literature. I think some of this is even talked about in Martha Hode's Sex, Love, and Race anthology. A lot of authors there are talking about these kinds of issues, not necessarily habeas corpus, but these marginalized people's use of legal mechanisms, and yet it hasn't really followed over into Western legal history. So I guess what I'm trying to say there is that some of the things I'm finding are very obvious to other regional scholars that just haven't been picked up in the Western frame. So that's why it's helpful to hear about these other works that, for instance, I don't read in 17th century English common law lit. So knowing, the scholarship that I can bring into that will only make it a richer analysis of the Western context.
Yeah, and I don't think, it's true. Stacy Smith has an article in our collection too, and I've also read her recent book on California. But
it's what I'm more familiar with is her California work. So.
Yeah, and so, but I didn't mean to imply that, oh, it's so obvious, but it's just a kind of another moment where, because a lot of freedom suits begin as habeas corpus suits, of slaves. Yeah. Freedom suits begin as habeas corpus suits, and so it's just another moment, as I'm seeing it, one of the things that's interesting, besides that it's just West, it's a different context, is the federal aspect, because you could not, as I said, you can't really have that, or at least not to my knowledge, unless there was some kind of way that the federal government would be involved in Native Americans' rights before Reconstruction because of the special kind of relationship. But other than that, in sort of regular civilian legal system, you couldn't have had these cases going to federal court until the period that you're talking about. So that makes it, I think, really, really interesting from a different kind of institutional perspective also.
Okay. I'll remember that. Thank you.
I just wanted to jump in really quickly. I think those were great points. It reminded me actually of Laura's work in People in her piece on the way people constructed narratives around, not so much for habeas corpus petitions, but for everyday legal actions, making claims about masculinity or appropriate place in the community as part of how you actually make arguments in even everyday legal disputes, regardless of what the statutory law is. That everyone knows if you're petitioning a county court that you make arguments about, you're a person of credit with long ties to the community. You could be guilty as sin, but this is an important part of any argument, whether it's a habeas petition or, stealing livestock or something. And I think that it would be interesting to see how that plays out in other kinds of cases in Indian country, and is this unique to habeas petitions or not? The other thing I was thinking about in earlier English common law history is some of Paul Halliday's work on some of the initial purposes of habeas corpus as a way of sort of the state keeping a check on its subordinate state actors, and thinking about the ways habeas corpus might have functioned in the larger federal Indian bureaucracy in terms of keeping a check on the minor officials out west from folks in D.C., in the ways habeas corpus can sort of immediately jump over venal or corrupt or otherwise nasty local officials, and the way that plays out in sort of state power structures and centralization that habeas corpus, Paul talks a little bit about how originally it's not sort of freedom of the subject, it's more about control of the king over his subordinate sheriffs and officials, and I wonder how much that plays out in some of these Native American habeas petitions.
I think you're definitely right to pay attention to that, because, and not only does it play out in the indigenous petitioners' cases, but in places like Seattle, where you have a very strong local anti-Chinese sentiment, and so you have white mobs who are basically kidnapping Chinese workers, but then you have a legal community who wants to impose its authority over those rabble-rousing white workers, and so they uphold the rights of the Chinese workers, and that's definitely a federal and local tension that's happening there. So it's happening in terms of controlling the Indian agents that are very far away from D.C., and it's also controlling the sort of the federal and local tensions in urban areas as well.
Reminds me.
Oh, go ahead, Kate.
Do you know Beth Lou Williams' work?
No.
She's working on anti-Chinese violence in the Pacific Northwest, and she's writing about those federalism type of conflicts. She just recently was hired at Princeton. She finished her PhD a few years ago at Stanford. I think she was a student of Richard White. So her book's not out yet. I don't know if she's published anything, but she's somebody you might want to. She would be really interesting for you to talk to.
Can you repeat her name for me, please?
Her last name is hyphenated. It's Lew, L-E-W Williams.
Okay.
And Beth. Baby.
Yeah, I'm going to go ahead and close out.
Should we? We'll go to another paper, I think.
Let's move to yours.
Okay, I'd be happy to. I'm going to be very brief and just say a couple of things about the paper. Like Katrina, I'm delighted to have your feedback or thoughts about where this can go. I started on this project really when I saw the National Archives had an index of black cases. They called it Black Washingtonians. It was an index of all the cases in Record Group 21 that were brought by or included African Americans, and a large number of those were petitions for freedom. But there were also criminal cases and civil cases and lots of other appearances that I'm interested in. But we've, in this first phase of the project, have really just focused on assembling as best we can the case papers of the petitions for freedom in D.C. in the circuit court between like 1800 and 1862. But my particular interest is in Queen v. Hepburn, and I had seen that case mentioned in Kent Neumeier's biography of Justice Marshall, and that Francis Scott Key was involved in it, and it just piqued my interest. And then I saw in the index at the National Archives that there were numerous Queen cases. This wasn't the only Queen case, and part of this paper, in fact, begins to recover the history of the case in a way that suggests possibly that Mima Queen's case may not have been the lead case, that in fact perhaps Priscilla Queen's case was the lead case all along. It's just that Mima Queen's was what eventually was taken up to the Supreme Court. I guess this part of this paper was about I've been trying to figure out the role of the white attorneys in these cases, much as Katrina was trying to do in hers. And at first I thought that Key was, I don't know, court-appointed or was working perhaps pro bono without much interest or knowledge of the families involved. I really didn't realize how deep that involvement went and how multi-generational it was, and this paper tries to lay out the timing of the Queen v. Hepburn case, and I was trying to figure out why it took until 1810 for these cases to come into the D.C. court. What might explain that when many of the cousins cases and relatives cases took place in the 1790s, and I guess I would comment that, you know, I've come to see the freedom petitions, perhaps particularly in the D.C. court, as much more than a minor drama, or much more than, you know, a sideshow that really didn't affect slavery at all, or that was just restricted to a handful of Upper South families. I think these freedom cases in this court are a central challenge to slavery at a particular moment when both the law and understandings of slavery and understandings of the implications of the Revolution were at stake and in flux. And so I think it's, you know, a really important moment. I guess last, this is part of a larger book project, which is going to look at pretty much three parallel investigations. One is into the structure of these families and their use of the law. I think that's along the lines Kate was just and Katrina were just talking about. Another is the rise of the Washington, D.C. Bar and court, and sort of the judges and the attorneys who are there. there are future Supreme Court justices, future attorney generals. This is a court that and a bar that hasn't really been investigated in much detail. And then third, I'm interested in the changing nature of slavery and freedom, as I mentioned, in this period. I guess I'm coming at this, and I think the petitions for freedom help bring some clarity about this. That slavery and freedom are changing. That freedom was not exactly something that was done by decree or some. I mean, decisions certainly had an effect, but I guess the point is that freedom was collectively constructed. It took generations sometimes to obtain, and it came in kind of incremental, not necessarily monumental steps. I think when we think of freedom or emancipation, often in just popular culture, it's the Emancipation Proclamation or some government decree that does this, that creates this opportunity. And instead, I think this helps us understand freedom as collectively nurtured, collectively constructed, and developed over multiple generations around networks of families through kinship and through legal action. And so, I think this is a particularly fluid moment, and that the decisions in this case and in this period are especially significant. I'll leave it at that and just seek your comments and suggestions.
Well, if I could jump in, I found your 3 reasonings for the timing of the case to be entirely plausible, and I enjoyed the paper, the way it was written, although, recognizing this is part of a larger project, it kind of becomes a little discontinuous when you jump from, I think it's page 12 in the paper, to explaining the entire process, or the process as a whole. But what would be interesting to me as you talk about this process of freedom, this process of manumission, is if you continue on with these cases, if you see the same kind of demarcation in the 1830s in terms of how freedom petitions are treated or aren't granted anymore, in the same way that we think about the South tightening down and becoming very defensive around that time. So it's interesting that you talk about this kind of opportunistic, fluid moment. So I wonder how the arc of that proceeds.
Yeah, I don't know. I'm I'm working on mostly the cases in the 18 teens, and I haven't really pushed ahead to the 1830s. But I am struck by how many of these cases. Well, we haven't also been able to do all of the genealogical research necessary to connect the 1830s and 40s cases to the 18 teens. So I haven't quite gotten there yet. I think that some of these cases are going to be similarly generational. That is, they'll be connected to some of these same families. But I don't know. I don't know how I'm going to address the implications of that. Right now, honestly, the book that I'm working on, I plan to keep it fairly tightly focused around this period, 1790 to 1815. And like Kate, going back to an earlier period, I've been doing Civil War scholarship for a long time, so I'm now looking at this early national and revolutionary period, and my eyes are opened, and I now think it's the most important period in American history. But anyway, I'll ask for more comments there. Okay.
I wonder if you've come across the work of Mary Beth Corrigan yet?
Yes. Yes.
Yeah. Okay. And also there's a dissertation by somebody named Kate Chilton, who went to Carnegie Mellon.
Yes.
and Kate Chilton's dissertation is really good. I don't know what happened to her. I mean, if she's publishing it or not, I don't know that I mean, I don't know anything about it, honestly. But it's, you know, both of them are very interested in the social history of African Americans and freedom, although I think Mary Beth Corrigan's work is probably later, I mean, definitely later than yours.
Yeah.
But, I mean, your framework and the part that's about family networks sort of reminds me of, and I say this with complete, you know, admiration, but it reminds me of like an older school of scholarship, right, that's kind of working really closely to the ground on, you know, connecting family members, and that's precisely what Mary Beth did. And but for a later period, and, you know, but, I mean, she was a student of Ira Berlin, and her dissertation, she finished her dissertation probably in the early 90s, and it's all about how families work to make other members of the families free, you know, and she's got a number of articles and then a dissertation about, you know, just the ways that families also would combine members of the family who were free, members who were enslaved. She talks about how they worshipped at the same churches, how they were often members of the same organizations, they lived in the same neighborhoods, and so you get a picture of a very, you know, a community where it's not like I mean, sure, it was very significant who was enslaved and who was free, but on the other hand, it's not like, you know, it was this bifurcated, you know, situation or whatever, and there were certainly like it was within families, and very, very often family members helping one another out, and obviously like the quintessential case in the history of Washington, D.C. is the Cook family, the John F. Cook family, right? And that's the one that's always cited where, you know, the mother way back when bought the children out of slavery, and they became one of the most prominent African American families in D.C. So, you know, I think it's like, I think it's really fascinating. I've also been struck just in my own work on how little has been written about the Washington bar and these epic fights these lawyers had with each other, you know. I mean, and you know, they were very, very interesting. And, you know, so I think it's just another example of how D.C. is kind of understudied. You know, I don't know. I mean, I don't know the scholarship in general on lawyers and kind of what are the stakes and what are how can you make your work on a group of lawyers and judges, you know, appear significant and interesting. I mean, I guess one way is to connect them to, well, these guys became Supreme Court justices or attorneys general or what have you. I mean, that certainly is. And just the notion that it's a milieu, I mean, I guess people have already been written in the past and are continuing to write, like in Rachel Sheldon's work, about the significance of kind of political networks in Washington, D.C., and they've done it more for legislators than for people who are involved in the law. So maybe that's another way of thinking about it also.
Yeah, yeah.
And the Maryland connection is so fascinating, and the Catholics, you know, these priests. I was reading that same article I read recently about Mahoney versus Ashton by Poppenfuss.
Yeah.
Which, by the way, has some pretty big mistakes in it, I think.
Yeah.
But I mean, the fact that these Jesuits were huge slave owners, you know, and the connections to Georgetown, and they draw this line between Maryland. They create the District of Columbia. What does that mean? You know, and it's just so I think the Maryland side of things is completely fascinating.
Right, and that way it connects to Tamika's essay about the boundary. You know, there's this legal boundary, this new jurisdiction that's in place, and I think for me has some real significance about how people, when they can time that litigation and what venue they're going to bring it in. I mean, the fact that this is an original jurisdiction now for petitions for freedom opens up what Maryland tried to close in 1796, and to push to its county level and remove it from the General Court of the Western Shore or the General Court of the Eastern Shore, you know, to push it back down to the county as the original jurisdiction. Well, then, okay, now there's Washington, D.C., and I think, Tamika, your essay talked a lot about this at the second half of the essay, with this porousness of the boundary, so that when emancipation occurs, who is it to be emancipated, and what is their status? Are they hired outside of the district, or are they actually residents of the district and therefore should be emancipated? Similar set of questions.
And it creates problems for slave owners because then there are all these rules where when they move into a jurisdiction, or after DC is created, if they move from the Maryland side to the Virginia side, within the district, they have to register. Right. And then they fail to register. So a lot of those cases are about, people who are enslaved bringing their cases and saying, this guy didn't register me in the books. And sure enough, he didn't. And then they can win their freedom that way. And so it creates a level of bureaucratic complexity that a lot of times it's like slave owners don't comply with, and then they get caught.
That's good. Thank you.
Sorry, something crazy happened. Can you hear me?
Yeah.
Yeah.
Okay, good. So I just love this case, and I love the way that you laid this out. Some of the things that it really reminded me of Letitia Woods Brown's work on free Negroes in the district. I mean, she's one of the few historians who really laid out sort of this early moment of freedom cases. And I think that you're right. Your instincts are right in tightly focusing on this period, because I do think it's distinctive, and things do change with freedom suits, particularly between 1820 and 1830. And so I think that this is a really nice focus here. I'm really interested in thinking about networks. I think that you have a really great opportunity. As Kate said, that this is sort of been an ongoing concept, this idea about networks. But I think there's an opportunity to sort of freshen our ideas about networks. And I'm interested to know, as free blacks such as Priscilla cross the borders, they go from Maryland to a place like Georgetown, how do those networks change? Or how are networks sort of compounded by additional networks, right? And then I'm also interested in sort of how you will conceptualize network more broadly in the work. Is the network about a black litigant's relationship to the legal system and those who operate within the legal system, or is it more broadly community-based? I think that you are making those generational connections, but are there other players involved? Because I think it's so hard and so frustrating studying early DC sometimes, because you know that there's something else there. I mean, you think about the escape on the Pearl, right? And the fact that 77 slaves found out about this and they're able to board this ship. There are networks there, and it's so hard to sort of grasp how these networks are formed and tied, and what an individual such as Priscilla's relationship to these networks might look like. So just sort of interested in I think that there's an opportunity here to think about networks across borders. There's a network in Maryland, clearly, that Priscilla draws from, but how does that network change when she arrives to Georgetown, when she makes this decision, to pursue this case? And so I don't know if you can play around with that more, but I think there's an opportunity here to think about networks differently than we've sort of typically treated them.
Tamika, that's really helpful. Thank you. It's just opened up, your comment just opened up a lot of ideas for me about how to maybe pursue that. A lot is not shown in this piece, I guess, obviously. Especially the family networks have been really working on both the legal documentation that's available, but also the records in D.C., in the Georgetown archives and in various archives at the Maryland State Archives, and a lot of these records reveal the intensity and the robust form that these networks took. But I think you're absolutely right. I need to think about how they change with mobility. And there's mobility that's across jurisdictions, and there's also mobility that that is within, say, Maryland. I mean, the opening of the family that I'm studying into Baltimore you know, and the sort of there. I can already see that there's this Baltimore network out there that's part of this whole story. But I'm just putting it together. But you're encouraging me, and I really appreciate it, to think about the mobility of people, and to think about the ways in which these networks are formed and then sustained. And certainly one archival problem is just that you know, a large part of the Queen family is held in by the Jesuits on various plantations, and most of what I've been doing is piecing together the groups of the parts of the family that are in different parts of Maryland, and what their relationship is to one another and to other people. And so there's much more to be done there, but the records really are the Jesuit records of their plantations, of their sort of their account books, their farm ledgers, and that kind of thing, that start to tell who is related to whom, who's where. When is one member of the family sent to work on, you know, in Cecil County, out in near Chestertown at Bohemia Manor, this other plantation they have. So I need. You're right. You're absolutely right. I need to pay more attention to this idea of networks across these borders and how they're, and particularly the border of D.C. and Maryland. I think that's absolutely critical.
I was thinking too, Will, that I think in my paper I might have referenced some of this work on St. Louis and the freedom suits there, and I was fascinated with the amount of detail on the attorneys that both Kelly, who wrote one of the pieces, and I can't remember the other woman's name, who also writes on it, were able to find, and so many of them seem to have parallels with the DC story, that, you know, you saw this slave-owning lawyers often being employed the most often for freedom suits in St. Louis, and there was actually some good, I'm trying to remember the details now, but I think in that Journal of Southern History article that Kelly wrote, Kelly Kennington, there is at least a couple of footnotes on the ways the lawyers were employed, either through informal networks or through people who had previously filed freedom suits, knowing, you know, who's a successful advocate and who has experience in that sort of realm. And I'm trying to remember more about it, but I think they were able to find out some good information about the attorneys there. I'm mostly curious, you know, in the long run, how much we could say about any sort of specialized practice in freedom suits. You know, even in DC, where there are many, I don't know if there are quite enough, you know, so that you would be a lawyer specializing in them, but it would be interesting to know what kind of expertise was built up over years. I mean, Key was doing these for over the course of, what, 25 years or something, he shows up with records? And how that change over time sort of affects the way they go about doing their work. And, you know, just the sort of intangibles of the law, you know, who you get to know on the bench, when's the best time to file, which sheriff is the best to send out to track people down. I mean, all these things are really hard to get at, but you learn with 10 or 20 years of practice on the bar.
Right. Yeah. Thank you.
Can I throw out something on that? Because an idea or thought. Like, I have to say that for some reason I was just sort of thinking about this. Like, I'm never surprised that slave owners would defend people seeking freedom in court, and I don't think that just because you own slaves doesn't mean that you would also not think that a person who said they were illegally held in slavery did not have a right to a hearing in court. And I think, like, a lot of times what you see in these, when you're reading legal sources, and I wouldn't overstate this, I think this could be overstated, I wouldn't overstate it, but is the thing about procedure and, like, a commitment to procedural fairness. And so, you know, somebody might think that they don't have a big problem with slavery as such, and they're happy to own slaves, but they also think if somebody is being held in slavery when they're actually entitled to freedom, they deserve a hearing. So I mean, you know, and I guess I've seen a lot of these kind of people who claim that the system works fine because people they'll say, like, look, we think our system's fine. Because, I mean, obviously, I think slavery was illegal, period. You know, like, in the present, it's like it was all illegal. It was all theft. But then their view was there are people who are legally held in bondage, and then there are people who are illegally held in bondage. Yeah. And some people wanted to make sure that people weren't illegally held in bondage. So I think I don't know, what do you guys think about this? Because I feel like that kind of question comes up a lot, and it's the kind of work that everybody's doing.
I mean, this reminds me of, like, you know, so some of the deeply racist lawyers and other people who supported anti-lynching movements. That it wasn't that they, you know, were hugely friendly to equality between all people, but felt that lynching was a procedural injustice, and in a way, you know, being anti-lynching helped support a system of white juries and civil procedure and criminal procedure that privileged their side, but that, you know, hanging someone in the public square, disemboweling them was beyond the pale. It doesn't mean they were, like, deeply anti-racist or believed in an equal justice system. It just meant that they were sort of proceduralists supporting a racist system.
I thought about this issue in regards to your discussion of the Mahoney case, Will, that you can see, based on your description there, that the petitioner had been found illegally enslaved in, I believe, 2 of the cases, but on the 3rd appeal, the owners did, in fact, get a verdict in their favor. So what I read that as is that the way in which the freedom petition mechanism worked did give enslaved people an opportunity to claim redemption, but if the owner had enough access to capital and enough time, they could appeal. They could basically pay out to appeal until they got a verdict in their own favor. And so I feel like that kind of taps into what Kate and Mitch are referring to, which is that you have a legal system that makes it possible for enslaved people to protest their enslavement. But there are still ways then for owners to circumvent or circumnavigate those mechanisms through their leverage of capital, basically. If they can pay to appeal enough times, it seemed like they might actually end up getting a verdict that they preferred. And I thought that was something that might be worth pushing a little bit.
Okay.
Just because it shows that not only can petitioners manipulate the legal system, but those being petitioned against can also find ways to push back. And if I can go off of that track a little bit to just make one more comment before I mute myself again. I wondered if you had, are you going to follow the Queen petitions all the way up to the Supreme Court?
Yeah. Yes. Okay. Yes. Absolutely.
So my question then is whether you thought that it mattered that these were women's petitions that ended up producing the verdict that hearsay wouldn't be allowed. I thought right away of Kathleen Brown's discussion of the silencing of women in colonial Virginia courts. It just seemed significant to me that these particular Queen cases were brought by female petitioners. I realize, of course, there were male Queen petitioners, but it sort of occurred to me so much that even if you're not going to follow that gendered angle, I think you should just mention it. That it may be significant, even if you're going to look at it from a different angle.
Yeah, I think it is significant. I haven't quite figured out how to address it. Well, first of all, this piece was just one little part to just address the timing. In answer to Kate's earlier comment, I agree entirely about the sort of possibility, or steering clear of overstating the idea that slaveholders are representing the enslaved. There is definitely this kind of commitment to procedure, and Key is a great example of this. And I've done a lot of work on Key, and I've got a whole chapter on, it's not formally a chapter, but I don't know, it's 20 or 30 pages on Key's relationship to slavery. And in this period, when and under what conditions does he manumit several slaves, and what does this tell us about his activity? And he also steps in 1815 and 16 to some sort of public crises in D.C., Kate, that you're probably familiar with, that are in Jesse Torrey's pamphlet about the slave trade in Washington, D.C., and it's Key and Elias Caldwell who and Key gets Caldwell involved, and even though Torrey just mentions Key's name once, I've got a lot more information about what Key was doing with those cases. In fact, those cases are in the archive, the digital archive, and so when you look at those cases, they're exactly along the lines you're describing. They're sort of false imprisonment, false free people who were captured on the road from Bladensburg to Washington and were just enslaved, and that they deserve to be heard. Their petition deserved to be heard. And Key is actively involved in that kind of intervention, and I think it's an important dimension and connects him to the colonization society and lots of other aspects of this mentality, Kate, that you just described. Katrina, I think on the women's cases, it's absolutely crucial, and I'm not exactly sure yet how to address this. But so the cases, in a way, are about women's bodies and women's histories, and who was Mary Queen, and what was her dress, and what signified her ethnicity, and therefore possibly her status as free, or possibly as enslaved. And so there's a great deal of testimony in the depositions in the 1890s that surround the kind of white male slaveholders' gaze of these women, and through multiple generations. Who were they? What does how is their status constructed and inferred? And all of this is brought out in the 1810 cases. But you're absolutely right. I don't know much about. I'm trying to find out as much as I can about Priscilla, Mima, her daughter Louisa, Alexis, and who, what that means for these cases. And I'm just not sure yet. But it's a really important dimension to it. Maybe in the interest of time, we should shift to we got to do at least two more. Tamika and Mitch, I think we should go to maybe 15 minutes of each. Can we do that?
All right. I'm sorry my paper was so long. I have a deadline. This is for a conference on citizenship in the Civil War. Some of you may be going to that at Virginia Tech next month, but they're considering putting together an anthology and wanted to have completed papers by April 1st. I don't think my paper is in any way completed, but there are words on the page. And so this was actually pretty tricky for me. The piece didn't originally start out being about citizenship. It really started off being about freedom and sort of the complicated processes of freedom that these women sort of underwent during this particular moment. And I stay away from citizenship, and now I'm here. So I am really excited about the opportunity to get your feedback. You all understand DC in more ways than I do, and would love to get your feedback and your suggestions. So I'll just go ahead and open it up.
Can I go ahead and jump in?
Sure.
Um, Especially since I don't know DC very well, so I'll just make my comments as someone who's an outside reader. First of all, I thought this was an amazing essay and very much ready to get circulated or reviewed for publication. So I'm glad to hear you have an intended home for it in a conference anthology. Um, I made page comments, so I'm just going to go through really quick if that's okay. In your very first paragraph, you outline citizenship as being about property owning, whiteness, maleness. Um, well, I should say property owning and whiteness, and I would just encourage you to go ahead and explicitly add gender as a key component of citizenship right away in that paragraph. You clearly explore it later in the paper, but since you're sort of describing what perceptions of citizenship entailed there, I think you can just go ahead and stamp Linda Kerber in that footnote and add gender to that. You have Evelyn McConnell Glenn in there, but Kerber's no constitutional right to be ladies, I think, is an important one to cite there as well. When you start to describe DC as sort of a unique legal battleground, I thought about some of the literature on legal borderlands, and there's a good essay on that by Mary Dudziak, maybe you're already familiar, in a special issue of American Quarterly. And I think that would be another interesting way to characterize DC, especially because that's something that both you and Will are picking up on, are the jurisdictional borders as well as the social and racial ethnic borders in DC. On page 7, you talk about white women who took advantage of the opportunity to be compensated for under the Emancipation Order. And I wondered if you saw, or maybe you don't care, and so it might just be my curiosity, but were those white women less likely to then challenge the constitutionality of the Emancipation Order the way that the white men were that you're describing? Do you kind of understand what I'm asking? It sounds like you make a very good point about how willing they were to apply to be compensated for their loss of property, but I wondered if they were less likely to make that step of challenging the constitutionality and basically denying the Emancipation Order the way some of the white men were that you're describing. And again, it may be beyond your purview or interest, but it did raise my own curiosity. On page 9, I thought you had a nice opportunity, especially if you're looking for ways to expand, to discuss the limits of the law in imposing social change. You talk there about how whites resisted recognizing black humanity and equality and the potential for black citizenship after emancipation. So basically denying the humanity and potential citizenship of freedmen. And so I think that's something that you could spin out as a conversation about the limits of the law in imposing social change. On pages 12 through 13, I think when you discuss the Brown case, you have more opportunity to unpack gender there. I think this is funny because you gave me a lot to think about with your question about patriarchy and autonomy in the native habeas corpus petitions, and I think I can see some of that in this particular section of your paper too, that you have an opportunity to maybe add or complicate your view of gender in that area. And then on page 16, when you talk about binding non-white minors as apprentices to whites, I just would note that by 1864, a lot of Western states and territories had incorporated this practice into their indenture and apprenticeship statutes, and so this is real common throughout the Reconstruction nation, and I don't know if you want to pick up on some of that literature as well. You may already have enough with your DC material, but I just pointed that out as a parallel outside of your region. And then on pages 16 and 17, I may have missed it in the footnotes, but Your discussion there is real evocative of Laura Edwards, so I would just make sure you're probably thinking of her when you're writing it, but I didn't see it in the footnotes, so I just would encourage you to go ahead and throw it in there.
On what page?
16 and 17. Again, I was usually reading these with another human being in my arms, so I might have missed it in your footnotes. And I apologize if I did. But those are all, my last comment was just that this was overall a superb essay. So thanks for sharing it with all of us, Tamika.
Mm-hmm. And thank you for your feedback here. I definitely want to unpack gender more, and I think I do sort of in my broader project. And here, I was sort of thinking, just trying to think about, you know, how can you look at citizenship from a lens of people who were enslaved. And I know many people grapple with this. This isn't an old problem. But I think there is an opportunity, like you said, to think about these slaveholding women and the white women who do challenge the constitutionality of emancipation, and those who don't, and those who sort of are really just interested in compensation and surviving the war. So I will definitely explore that. And add my note of Laura Edwards, who is repeatedly mentioned throughout my dissertation. Her and Kate are all throughout my dissertation, and so this so I do need to put her on those pages. But thank you for your comments. I was typing them up as you were saying them. I definitely will revisit them.
Mike here. Oh, hi. Hi. So can I go?
Yeah, sure.
Oh, okay. Obviously, some of this stuff I really know well. I guess I want to be completely encouraging of your project. I think this essay, I'm not quite sure what it's over. I think it needs more focus. Yeah. So as a standalone piece. And so, you know, if you're moving forward with publishing it, and sometimes, you know, it's weird with edited collections, you might or might not get that much feedback. It won't get the same kind of intensive peer review as it would get if it were going in a journal, which can be nice too. But so I think if you want to sort of go with the citizenship angle, that you really need to define what you mean by citizenship, and that's not just to be annoying. I'm not just, but you know, the way that I have grappled with this issue is to try to like look at it pretty much from a strict and kind of legalistic perspective, and that's why I wrote in the introduction of my book that I gave up on using the category of citizenship because it just didn't seem to apply. But I can totally understand how you can apply it as a kind of more cultural category of belonging and kind of dignity, and that's fine. But if that's where you're going, then I think you really need to, you know, make that clear. And I think there are two recent essays that are significantly focused on freed women and emancipation that you kind of have to grapple with in a new essay like this. And they are both, I think, in the Journal of the Civil War Era. One is by Chandra Manning and one is by Thavolia Glimpf. And, you know, so, and then there's Amy Drew Stanley's AHR article, which is called something like Instead of Waiting for the 15th Amendment. And all three of them, Stanley's is much more kind of it's a little bit more top-down, but Chandra Manning is making a very, very explicit argument about freed women in not concentration camps, in contraband camps, sure, and citizenship. And then Thavolia is saying something rather opposite about the non-availability of citizenship to African American women at the moment of emancipation. And so rather than being a problem for you, I think these essays could really help you frame yours, because they will give you some very clear kind of benchmarks where you can say, look, you don't have to go so far as to say, oh, I agree with this and I don't agree with that, but a vocabulary, a thing to respond to. So I think that could be helpful for sort of helping you structure your essay and kind of giving it a little more momentum. I mean, you know, some of what you're writing about reminds me of the chapter that I have in my book on the Freedmen's Bureau and marriage and schools. That chapter has more about gender than any of the other chapters in my book. And you know, it was in 1865 that the Freedmen's Bureau, that Congress passed a law that was specifically for D.C. retroactively legalizing marriages among slaves, and that in part was really relevant for housing for free people in D.C. because they originally had, I tell this whole story, whatever, they had this original policy where you could only live there if you were a married couple, but then, you know, and then there were all these people who were like, well, I'm not here with my husband, and a lot of them, the migrants were disproportionately women, and so with kids. So, you know, I think there's stuff you could draw on from my book. I'm not trying to be self-referential, but, you know, kind of draw on that to help also. And then I remember really clearly that the first reel of Freedmen's Bureau records for D.C., the letters, I can't remember if it's letters sent or letters received, but it's like one after another of freed women going to the Freedmen's Bureau asking them for help reclaiming their children from slavery and apprenticeship, especially in Maryland, but also in Virginia. And so rather than relying on the records of the Freedmen's Society Project, I would really suggest, if you haven't already done it, to just use those microfilm reels because they are so extensive and there's so many women in them. And it was one of those things that I wished I had a way to write about, and I didn't. I just had, like, I quoted from like a couple of those, but there are so many of them. And they are, I mean, some dads are going to the Freedmen's Bureau and asking the same thing, but it is vastly more women. And they're going out into the countryside. They land in D.C., then they go to the Freedmen's Bureau, then they go out into the countryside with a Freedmen's Bureau agent and have these confrontations with their former owners. And, like, you give me my children. And so, you know, I don't know, maybe you have a whole other thing about that somewhere else in your dissertation, but I just think those are, you should completely mine those records.
Definitely. So I do have those records, and
Yeah.
and I actually, so we made a decision in my committee to cut my dissertation off by a certain date, and that was by the end of the war. And so a lot of those sources that were in this piece got cut out and pushed off into an epilogue somewhere. So, as I'm sort of rethinking the larger book project, I really do want to use those sources because I think they're really meaningful. And thank you for the Chandra Manning and Thavolia Glinton and Amy Drew Stanley pieces. I have read them, and Thavolia is one of my advisors, and is sort of advising me through the book project. And so I definitely do subscribe to sort of the non-availability of citizenship piece, and I think that's why I named it By Stealth. I wanted to highlight Jane Camper's idea that that despite the lack of rights and the legal backing to do what she needs to do to realize freedom, that she does it anyway, or despite the fact that the courts may not always allow me to have custody of my children, I take them anyway. And so that's sort of the ongoing narrative in much of my work, which is why I mine mostly the criminal records. And so this is sort of the only part towards the end of the dissertation where I'm thinking about these other Freedmen's Bureau records and these letters and petitions to the commissioners and that sort of thing. But I do need to situate myself in this scholarship, as you have shown. So I definitely need to do that. Defining citizenship is something that I've been sort of grappling with in this piece, because I'm also thinking about the white actors here who are defending their idea of citizenship, but then also these black actors who are challenging that citizenship. And they're not always claiming citizenship, but they're challenging white citizenship. And so I need to make that clear, more clear in this piece. But thank you so much for your comments.
Sure, you know, and that's why, I mean, personally, that's why I think citizenship is so tricky, because to me, citizenship implies a relationship to the state. Mm-hmm. And if what the, like, black women that you're writing about were most concerned with was not their relationship to the state, but was more their, bringing their families back together, finding a place where they could make a life, that didn't require oppressive labor and oppressive relationships with white employers or whoever. That's, to me, we collectively, it's like we don't have a very good vocabulary for that kind of thing, and I think we could call it a kind of citizenship, but then I think it just you sort of end up conflating it with precisely what you're talking about the white people's vision of citizenship, which is I have special rights, I have special privileges, I get to vote, and so it I don't know. To me, it's just sort of ends up in this tangle anytime you get like far from the official definitions. Which isn't to say that we can't write about about other visions of what a good life would be. It's just that like when we start to use the terminology of citizenship, we tend to get like dragged into things that don't necessarily mean that. But that's just
And and I think I'm willing to be dragged in a bit because much of my work is about criminality, and as much as these women don't have a say in what happens in the state has a say in what happens to their lives, and in that and can regulate their lives and can create surveillance mechanisms that control their lives in very interesting ways. And so I think that I'm still searching and still trying to work through and do the good thinking that I need to tease out what is some good language to think about this. But I do try to reserve citizenship in this particular moment as a white privilege. Not to say that Black people weren't making claims to citizenship, and not to say that they did not desire citizenship, but their status solely did not reflect that. And so I'm trying to work through that. But they are interacting with the state, whether they want to or not, because the bulk of my work is focused on sort of these legal mechanisms, these Black codes, these slave codes that funnel these women in and out of the workhouses and the jails and that sort of thing. So I think I have a lot of work to do in terms of thinking about that, about sort of these alternative languages for citizenship. How do we think about the sort of unique status of enslaved and free Black people and other people of color at this time who don't have the same privileges that help them inform how laws are made, but whose lives are still controlled by those laws.
Mm-hmm.
If I can just briefly interrupt to say that with our late start, I actually have to go introduce a major conference here on Armenian genocide, and there's scholars from all over the world have come, and it starts in 7 minutes, and I'm supposed to walk over there and give the opening welcome to the several hundred people. So I'm going to sign off, but I want to just thank everybody for the comments so far. I've really gained a lot of insight, and I really appreciate your participation. I know, Mitch, your paper is next, and I hope that y'all will stay on for at least a couple more minutes longer. I think there are some people who are watching this, students and scholars who are watching it on the YouTube stream, and I hope that you all will stay on and finish out the couple remaining papers. But I am going to have to go.
Bye, Bill.
Bye. Thank you, Kate. Thank you, Tamika.
Pleasure.
Thank you.
Thank you, Mitch. All right. Talk to you later.
Bye.
Bye.
Do we want to go ahead and switch gears then and jump into Mitch's paper?
Sure.
Sure. Yeah. Actually, I have to go in about 15 minutes too, so maybe that's a good idea. But I did want to say I thought Tamika's paper was fantastic. I really like the focus on legal geographies too. I mean, I think too often it's hard for people to understand just how much these so highly arbitrary lines in the sand on the physical geography matter in legal terms, and how seriously those are taken in ways that sort of boggle the mind, especially something as fragile as the line between Maryland and DC. So, but to my paper, I'm not an American historian or an American legal historian. I work on British India, but my other interest is history of the book. I'm a curator here at Special Collections Library, and I teach mostly material culture and digital humanities. So I'm interested in legal forms, which everyone nods off when I start talking about. But I'm very interested in the sort of material practices of courtrooms and archiving documents, and what it actually takes to go through the process of a legal dispute. And it was fantastic to get a chance to use this archive that Will and others had digitized to sort of see something in macro. I'm used to reading court cases one at a time, things that I'm interested in, so to look at all 250 and over 1,000 documents all at once was really fun for me, and getting a sense of what the legal archive looks like en masse, and then trying to make some conclusions out of it, which are more or less successful. I'm especially interested in what kinds of legal processes get enabled by technologies like printed forms, and which ones are left to manuscript, which is sometimes more of a telltale sign than others. But I found this an especially interesting archive for what it can tell us about legal knowledge and how it's distributed. So thanks for taking a look at it. It's sort of a fragmentary thing, but it was fun to get a chance to work through that archive.
Mitch, can you say something about what your goals are for this piece?
Oh yeah, this was sort of something I put together for Will in this discussion. Eventually, I'm interested in looking at legal process and forms across Anglo-American law. So looking at a broader sort of 1700 to 1900 period of change in legal practice based on material form. So it was a nice exercise for me to try to make sense of something that I was sort of coming to new and see what I could make of it. I'm especially struck by what kinds of documents these files include and which ones are missing. I was actually struck by the number of actually the petitions that were missing. Not many, but if you were to ask me what every single file in Freedom Petitions would have, I think the petition would be one of them. So it's interesting to me to see what ends up in the record and what doesn't. And the sheer number of summonses, of course, is not really a surprise, but their ubiquity, I think, can tell us something interesting.
Actually, your paper made me have a question about the sample itself, which I'm still not clear on, because I know that list that Will's talking about of indexed. Somebody made this index of cases involving African Americans, and then it sounded to me like Will was saying that was what had been digitized through the project. But then I wasn't clear whether that was what you were starting with or whether you were starting with some other sample.
I mean, I actually know very little of the. This would be good but Jeremiah, you probably know. I'm just using the 1,207 or however many documents are in the online project. I don't know, and that's about 250 some cases. I don't know how many of those 250 some cases, are drawn from that list and how many extra ones are on there. I assumed it was the majority. Jeremiah, do you know what the selection process was for digitization?
I don't. I know it is expanded over time since the origins of the project. Just looking at Freedom Petitions, I think. See, this would be something that Dr. Thomas would have to speak to, but I think that they're trying to get just as many documents as they can now at this point in time from the entire antebellum period scanned in and digitized. And I don't know where it will end up, but I know the initial project was just the Freedom Petitions. Yeah,
my impression is all of these are, but the question is, are there another like 80 Freedom Petitions that weren't scanned in this batch, or that I don't know.
Well, anyway.
I don't know where they're at in the process.
But I guess the point is, it actually has no relationship to being a snapshot of what the court actually did as a whole.
No, right, yeah, the entire legal business is going to look very different, but it was interesting to see this very niche group, and that's a good question of what these sort of outliers, of the practice in any given sessions at DC. I mean, these are going to be if they occur at all, a vast minority of what the court's business is. But it's sort of interesting to see what flows over from other business. I mean, the majority of printed forms in these cases are absolutely identical to all the other printed forms used in every other case. And looking at what gets specialized treatment in the sort of very physicality of the documents and what doesn't. Insurance disputes have their own forms. Those rise to the level of these are special enough and frequent enough and have a jurisprudence developed around them enough that we need special forms. It's in fact not a surprise to me that freedom petitions don't have the special set of forms, but I'm still curious to find any out there. I know in South America there are some printed forms having to do with manumission and in freedom, but I'm always interested to see what gets printed and what does not.
Hi, this is Lee Vandervelt. Can you hear me?
Oh wow! Hi. Yes, we can.
I've been trying for 2 hours to get on. Hello from Munich, Germany. I've read all of your papers and I've really enjoyed them, but I realized that Will just signed off. I could see that, and I don't know if you're all so close to the end of the 2 hours that you allotted that you would like me to hear my comments or not. I'm so sorry it's taken so long to get the connection to work.
Don't worry, I think a lot of us had trouble getting on. I think it was a pretty common experience. I do have to run in about 5 or 6 minutes to another event, but I would love to correspond with folks on email or especially about my paper or just court documents in general. I'm really interested broadly.
Okay, and so go ahead.
I don't. Kate, I know you and I recognize you, but I don't think I can recognize who the other individuals are.
I'm Mitch Frost here in the right-hand side, at least of my screen.
Hi, Mitch. Nice to meet you. So you may know that I've written a book called Redemption Songs on freedom suits in St. Louis.
Yes.
And I think I've been coming to reading these papers from the perspective of the St. Louis freedom suits. And I just want to say how thrilled I am that the District of Columbia suits are online, that people have been able to make such interesting use of them. And perhaps the best thing for me to do would be to start an email correspondence with each of you, giving you the comments that I have as I've gone through each of the papers or tried to go through them thoroughly.
That would be great. Thanks.
I'm sure Dr. Thomas would appreciate that too, Lee. I know that he would definitely regret missing you, but he had to leave to introduce an invited speaker on campus. So we'll be sure and let him know you joined us right after he left. But if you could email your comments to us, we would be really happy to have them. Thanks for offering to do that, Lee.
I think that might be the absolute best way to do things because I haven't been able to hear the totality of the discussion, and so I might be covering material that you already covered.
This actual conference or stream it is captured, so it will be up. And fortunately, I will be able to edit out the first 20 minutes of chaos.
Really, there was that much. Well, it's a success to even get through, right? So I think we have to feel good about that.
Mitch, since you have to go, is it all right if I also email you?
Yeah, no problem. No, it's been great hearing the conversation, too.
I did enjoy your paper, and I thought your insights about what those printed forms and manuscript forms allow or obscure was really compelling. So I'll send you an email with my comments. And Tamika and Jeremiah, I'll do the same for both of you. I know we did get to discuss Tamika's paper and not Jeremiah's, but in case you weren't able to keep all the notes, Tamika, I'll just email you what I had. And I am actually going to go ahead and sign off as well. Kate, it was wonderful to get to hear your comments, so thanks for joining us, and Lee for coming in and making your way. And Jeremiah, thanks for working to put all of this together. I think it's pretty clear that the Google Hangout problems were on the site and not on your end, so don't feel like that reflects on you. Thank you, everybody, and I look forward to seeing you guys at a conference sometime soon. Thank you.
Yes, thank you all. I appreciate it.
Mitch, I'll go ahead and email you my comments as well. I really like your study of just the documents themselves. I think more needs to be done about that. And being from UVA, that's a big for us. So I think that there's tremendous possibility, not only with this piece that you're working on, but also with working in digital humanities and thinking about a variety of digital interpretations of documents and looking at the inconsistencies and the consistencies with the documents. And it might be worthwhile even, I think that there's a fellowship, and I think Will actually did the fellowship at one point, but that invites digital humanities scholars to come in and really play around with these documents in ways that help us extract some meaning from a variety of ways of interpreting, particularly hefty data like that. I mean, hefty to us, right? You know, science, big data, people are like dealing with, 50,000 documents, but historians are like, oh, there's 1,500 primary documents. So it's a really great way to think about doing that, and maybe we can email exchange and talk more about that. But I think that there's some great possibilities with thinking about the function of the database, the image of the document, and I even think it might be interesting or worthwhile to examine the changes over time in like legal documentation practices of freedom suits or something specific that interests you, that helps you sort of extract more meaning about the language of law that you talk about in the title of your paper. Yeah. But we can talk more about that, and I will send you a comment. And
one question that I wanted to ask whether you had covered was the way that the freedom documents that have been discovered depart from what's recorded in Cranch reports. Some time ago, I had sent Will a list of what I found in the Cranch reports in contrast to the freedom documents that are online. And there's both underlap and overlap, which I thought was interesting.
That's fascinating.
That's
really interesting.
I specifically looked at that. I've actually gone through those documents and tried to match them with Cranch reports. So,
did you find the same thing, the overlap and the underlap?
Yeah, I did. Mm-hmm. And I didn't look at them online, but I looked at the the actual ones, and I have it's kind of a crazy making experience. But while I have the floor, let me just say, Mitch, I mean, I agree. I think for those of us who are not, I'm always feel really enlightened by people who consider themselves history of the book people. And I think one of the things that really challenges regular historians is to contend with the formulaic nature of legal documents, because a lot of times if you're only let's say you're just a regular historian and you're looking for one case of one person that you're interested in, and you find it, and then you want to feel like the language that they're using is the language that they really did use or that their lawyer used. But then if you take the perspective of looking, at a really big sample size, or you understand how forms work or how the law works, you see that, the language is formulaic, and it's formulaic on lots of different levels, from the forms themselves, which can be identical and just have fill in the blanks, to the kinds of claims you have to make in order to win your case, right? So you have to claim, I can't remember what the language of a divorce suit is, but it's something like whatever. So there's always these kind of key words that you have to hit, and so we don't always know that's not necessarily a representation of what that person wanted or experienced, but rather their attempt and their lawyer's attempt to fit them into a winning model for their case. And so I think what you're doing can really, really help us understand the kind of what you can and what you cannot know from looking at these documents.
Right. That's great. I first came to legal history almost through looking at a series of criminal indictments from the 17th century, in which, as a graduate student, the language, of killed by force of arms through blows aforesaid, or I was basically interpreted all this stuff into this one indictment before figuring out as a second-year graduate student that every single criminal indictment had the same language. And that was a huge revelation to me that what I thought had been really descriptive of this really violent crime was, in fact, just in every English criminal indictment at the period. So I think that kind of work is really fun to do. So I wanted to thank everyone. I have to actually run off now, but I really enjoyed reading this and we'll see more on the site as it grows. So thank you, Jeremiah, for putting this together, and Will, and I hope you're able to continue the discussion.
Thanks, Mitch.
Thanks.
Thank
Bye.
you.
To address your question, Leah, Dr. Thomas and I had a discussion about the Cranch manuscript. I think it was at your urging. I think he mentioned that. And I spoke with Herb Johnson, former editor of Marshall's papers, and he said that so much was left out of Cranch's manuscript when it came to the reports that we were kind of wondering that as well, if Cranch purposely left out from the documents to the reports, or if he had the stuff in the manuscript and that was cut. And Herb Johnson told me that a lot of the stuff is in the manuscript, so you might get a better idea by just comparing Cranch's manuscript with the documents of what he was going for initially.
Where is that?
He thought it was in Maryland or Massachusetts. No, Massachusetts.
Why would it be there? What collection would have drawn it there?
I don't know. He's obviously relation to the Addams family.
He was from Massachusetts.
Yeah, through marriage.
Mm-hmm.
So I don't know which particular collection. He mentioned it, and that's something that I haven't looked into yet. But it was a suggestion to try to get that digitized as well to put up, so you could kind of toggle back and forth. But that probably is, outside the bounds of time and money for this project, unfortunately.
The interesting question that it raises is a record of what it is that we can find in these extraordinarily valuable primary documents. Are we getting 80%? Are we getting 70%? And then also, why is it that Cranch has some things that have been lost to the light of day? Is that why there's freedom suits in Cranch that then don't show up in the primary materials? And so if we begin to get some sort of sense of what we might be missing because it occurs in one place and not in the other, I think that we can be more cautious about claims that we can make, given the state of the information.
I think that's a good point. Just to transition, I just want to make a couple comments about my paper, which was, when I was at the conference, I talked to Lawrence Friedman, and he said, what would be interesting? If somebody just took in, 10 years intervals, looked at the business of a court, just strictly the business, what's going on in the court in that time. So my paper was kind of entering salvo, if you will, a shot across the bow to doing something like that, just looking at the first 3 sessions of the court and what kind of business they transacted. So, a real cursory look. The only thing I really found that I think I could draw a conclusion about that early, obviously I would need to look at further minute books, was that the court really facilitated economic development, not instrumental in nature in terms of setting policy, but just administrative. It was really a bureaucracy for getting the economy going in D.C.
Do you have any sense of comparables? When I was reading your paper, I was thinking, how is this different? Because this is the District of Columbia from what would be the similar equivalent court in Philadelphia or New York. Does the fact that it's the federal district have any unique significance to the quality or the nature of the business that the court is doing?
I don't, and that's, maybe you guys could provide some input, but I haven't seen much out there on the actual business of a court, especially antebellum courts, before all the federal, courts were required to report to the Attorney General on all their business. So I haven't seen much of anything out there, and that would obviously take some digging to do some comparisons.
There is, the material is available for St. Louis. Again, it has to be dug into, but at one point I was trying to quantify murders versus probate disputes versus any range of the types of civic, local work that a court does, and that's available for St. Louis, and they've got a really lovely index and a spreadsheet on it. So that might provide a basis for comparison. Admittedly, it's not a, it's a frontier rather than a seaboard state, and to that extent, there might be some difference that can be drawn just from those two locations.
Okay.
Well, I'm going to sign off too. I think I don't want to preemptively close the meeting, but I just want to say, Jeremiah, thank you for your logistical work, and Tamika, it was really nice to connect with you. I've definitely heard about you and your work already, and so it's nice to meet you, and I hope we can continue the conversation if you want. You're welcome to, follow up with me if you want to.
Wow. You work with my cousin. Do you know Jennifer Richardson?
Is that your cousin?
Yeah.
That's so funny. I recognized that you guys had the same last name, but I just assumed that there are plenty of Richardsons in the world. She and I actually were in college together.
Oh, wow.
Yeah, so when I got to Northwestern and she was already there, and I was like, I know you. So really funny too.
Oh, well, it was so great meeting you, and I'm in the Midwest now. I'm not in Virginia anymore, so I'll be at Oberlin. So I'll be I just accepted a tenure track faculty position there. So
oh, congratulations! That's wonderful.
Wonderful.
So I'll be in this area. So if I'm ever in Chicago, I'll have to contact you.
Yeah, I'm not there now either. Wait, are you there? Well, right now I'm in Boston for the year, but I'll be back as of July. So have you already moved to Ohio?
I have. Yes.
Okay.
Yeah, I'm from Ohio, so it was an easy move. I'm crashing with my parents.
Oh, that's cool. Okay, so so anytime, let's just see if maybe we can get you out to give a talk or something too.
That'd be great.
So anyway, and Leah, nice to see you again, and thanks again. This is a cool project.
Nice.
Thanks
Bye-bye.
for your help in this, Kate. Appreciate it.
Call on me anytime. Okay, bye-bye.
Bye-bye.
Bye-bye. Tamika, I had some really, I had a really wonderful time reading your paper, and I think that the best thing to do now that there are only 3 of us here is for me probably to send you those by email. So I think that that's what I'll do.
That'd be great.
How long have you guys? How long have you guys been going?
How long have we been conferencing?
Yeah.
Probably for about, I don't know, since.
It's 2 hours.
It's been 2 hours, right? I mean, I don't know when I got on the call because I just sort of kept pushing buttons everywhere. But I got on here, and I think I was the last person to get on. Well, you after you, before you.
Yes.
Awesome. Well, thank you for taking time to create comments for me. I look forward to reading them.
Thanks very much. And Jeremiah, thank you again for setting this all up for us. So I'm going to go back to the wedding party.
All right.
Which is why I'm here. I'll say bye-bye.
Thank you very much.